I'd like each of you to take 3 minutes or so and run through what you think the key takeaways practitioners should leave today's webinar with from your presentations. Let's start with you, Rod Honecker.
Thanks, David. At the risk of stating the obvious, if you're a lender, creditor, make sure your loan documents are squared away and properly filed and recorded. The better the collateral package, the better. It's always good to have a personal guarantee from a principal of the business, so they have skin in the game. To the extent you're a non-lender, just any creditor, get as much information as you can on the assets of the debtor as early as you can. Once you have that knowledge, then you'll know what your options are from a collection and litigation perspective, and you can properly assess the cost-benefit of how you intend to proceed. Let's face it, the lawyers are not cheap. We're going to burn up some cash, and in effect, that's going to come off of the recovery. I mean, there are circumstances where you can get fee shifting by statute or contract, but of course that assumes that the debtor has the wherewithal to pay the attorney fee shifting as well. And if you have your money judgment and you are convinced that the judgment debtor is not capable of paying the judgment, and you're not willing to bite the bullet of forcing them into a Chapter 7 and being considered an unsecured creditor and getting pennies on the dollar, as the scenario that Nick was talking about, consider a settlement agreement with the judgment debtor or a forbearance agreement, so you get payment over time, maybe add some collateral or a guarantee. Something is better than nothing.
Stephanie Record.
Yes, thank you. My key takeaways are just first and foremost to check the security agreement before even thinking of judicial action or repossession. But if you are going down the self-help and repossession route as a secured lender, it's really key to check your default provisions. Are there any time requirements? Are there any grace periods allowed? To really ensure that the borrower is in default and that you have a valid security agreement in hand. Also, review the notification forms that you're using. I can't say how many times we get a litigation where we're looking at the documents and they're out of date. It's simple. The UCC provides forms. Use them, or just make sure that your forms are code compliant. And then the cost-benefit analysis that must occur. How much is owed on the debt? Are repairs going to be necessary? And not only will they be necessary, will they be deemed commercially unreasonable if they're not made, because it would result in an increased sales price. How much will the expenses be, and from repo to sale, and what is the equity in the collateral? There is case law where there simply was not enough equity to justify even repossession. The courts have found those actions by secured creditors to be commercially unreasonable. The actual amount owed by the debtor increases because of the repo, and it's not, and the collateral can't even obtain that amount. So you're just increasing a deficiency judgment. Courts don't like it. And if you're unsure of the value, and one key thing that I did not get into in my presentation is get an appraisal. Then the issue of price can't be attacked. So many times the issue is that the debtor is claiming the secured party didn't obtain the highest sales price. Well, if you have an appraisal in hand to say that this was market value at the time of the disposition, you're pretty much golden. So those are my key takeaways as far as my points.
Thank you very much. And finally, Nicholas Brzezinski.
All right. Well, it should be obvious that I think that it is really important to consider where you are filing for what and when. So, if you're the creditor or a bank or just a regular vendor creditor, know why you're filing in a particular jurisdiction and what the risks are. Some jurisdictions are much quicker than others. Some afford different remedies than others. Not all jurisdictions, for instance, have writs of attachment. Some, as Rod described, are more difficult to obtain, and some are easier. In California, there's the risk if you're an out-of-state plaintiff that you're going to have to post a bond, and that's another motion to oppose that could cost tens of thousands of dollars to deal with. It's really akin to a motion for summary judgment. If there is fee shifting, there's the risk that the fees are going to shift to you if you sue for the wrong amount as a creditor. What is the success on the merits in the state that you're looking to sue in? That's a good question that you need to talk to your attorney about. Or if you are an attorney listening to this, it's something that you need to know in order to advise your client about the risks of an inflated claim. And then finally, with regard to BK and bankruptcy, it's important to adhere to the rules in bankruptcy, not disobeying the stay, filing the motion for relief from stay if you do want to proceed, and it's important to know how to claw back those fraudulent transfers